Joining us now is Benjamin Crump, an attorney for the family of Breonna Taylor. Mr. Crump, good morning to you. It has been a very difficult night, protests that have turned violent. How is the family doing this morning, and what was their reaction to hearing this decision?
They were outraged, they were insulted, and they were mostly offended because, like my co-counsels, Sam Agar and Lanita Baker, we're trying to figure out what did the Kentucky Attorney General Daniel Cameron present to the grand jury? Did he present any evidence for Breonna Taylor? And if he did, what was it to get an outcome like this?
Ben, the Attorney General said yesterday, apparently part of the evidence that was presented was this idea of self-defense, that the officers only fired because Breonna Taylor's boyfriend fired first. What do you make of that argument?
Well, Craig, the self-defense argument in Kentucky, as in many states across America, contemplates that you cannot use violence against a third-party innocent bystander like Breonna Taylor. And the fact that her boyfriend, Kenny Walker, who has a right to the Second Amendment like any other citizens, even if he's a black man, they thought it was intruders breaking into their home. He thought he was protecting his woman and his castle, and that begs a deeper question, Craig. Why didn't Daniel Cameron present to the grand jury anything about the lie in the probable cause affidavit to get the no-knock warrant that allowed them to be and bust in Breonna Taylor's apartment in the first place? Her family, as do I, think these proceedings were a sham proceeding that did not give Breonna Taylor a voice.
What do you think of the charge that was filed? I mean, here you have one of the officers now charged with wanton endangerment because he fired a shot that ended up in the neighbor's apartment in the hail of gunfire that was exchanged that night.
You know, the wanton endangerment charge, it just doesn't make sense when you think about they had wanton endangerment for the white neighbor's apartment, the bullets going there, but not for the bullets going into Breonna Taylor's body, nor did they have wanton endangerment for the bullets that went into the black neighbor's apartment above Breonna. It underscores what I've said many times. We seem to have two justice systems in America, one for black America and one for white America. And I have to say this, if you have wanton endangerment for somebody shooting blindly or officers shooting recklessly, wouldn't that rise to the occasion of wanton murder in Breonna's case? Because she died. Daniel Cameron, you need to make that argument to the grand jury. Breonna's name wasn't even listed on the indictment. So you talk about transparency. Breonna's family would love to see the grand jury transcript to see if there was any evidence presented for Breonna Taylor's perspective. I mean, nothing seems to say that Breonna mattered.
Ben, last question here. I mean, the state investigation appears to be complete. There is this FBI investigation now. How optimistic is the family that there may be some justice on the federal level?
You know, my co-counsel attorney, Lanita Baker, feels that the FBI has done a lot of work to try to look at every aspect of this execution of this no-knock warrant to see if civil rights violations were done in this case. But truly, this is about Breonna Taylor. And if you are a parent and you have a daughter, if you have children, you can't sleep peacefully at night knowing that this daughter of Tamika Palmer was allowed to be executed, and for our legal system to say it was okay.
Mr. Crump, thank you for your time this morning on a difficult morning. Thank you very much. We really appreciate it.
Thank you, Ben.
Thank you, Craig. Thank you, Savannah.